under advisement and go to the next case on the calendar, please. It is case number 24-7353, Liberty Northwest versus Atlantic Specialty Insurance Company. Thank you again, and thank you to your advisor. Counsel, before you both argue, I just want to remind you, Judge Hurwitz is participating by video, and sometimes there's a little bit of a delay. So if you could just sort of bake in a bit of a delay, that'll make it a lot easier for him to get his questions in and help us from talking over each other, which we try to do, although it doesn't always look that way. But that's what we're trying to do. We're ready to hear your argument when you're ready, counsel.
May it please the court, good morning. Chester Hill, I'm counsel for Liberty Northwest Insurance Corporation. My intention is to reserve 5 minutes for rebuttal. What's this case about? It's two insurers, one who defended a case, a second who didn't. And the first insurer, my client, their position is that the non-defending insurer, Atlantic Specialty as they're known today, One Beacon as they were known 15 years ago, was wrong for doing that.
For not tendering a defense.
For not defending the insured that my client defended.
Right. And so we're going to look just at the four corners of the complaint.
Right. And that's I think, the most important thing at issue in this case. We look at the four corners of the complaint, we look at the four corners of the insurance policy at issue, and we ask ourselves, does the underlying complaint assert a claim covered by the policy? And
isn't the issue even more narrow? Because as I take it from the briefing, the question is whether or not one of the exclusions, one of the three identified exclusions in the policy means that there's no coverage. Is that a fair statement of what the issue is?
That's correct.
We don't need to read the rest of the policy. We just need to figure out, well, we need to read it, but the issue is whether the exclusions cover this case.
That's correct.
Or I think, said a different way, unambiguously foreclose coverage. I mean, yeah. I think that those words are important because here it is sort of a higher standard. We have to be able to say that they unambiguously foreclose coverage for the particular claims that were raised in the underlying complaint.
That's correct. And I think you're teeing up two different issues. Judge Hurwitz is correct that we are worried only about those three exclusions. For purposes of this appeal, those are the only exclusions that are at issue. We're not looking at any other provisions of the policy. Those aren't in dispute.
And the policy would otherwise cover this, but in your view, or in the view of the judge below, but for the exclusions, right?
Correct. And second, Judge Desai, you're also correct that there are three or four sort of subtopics within the analysis of the duty to defend that are very favorable to my client, the insurer saying that Atlantic Specialty should have defended, and they create a very high bar for Atlantic Specialty to say that they were within their rights to not defend. Those include the idea that any ambiguity is resolved in favor of coverage. They include the idea that claims or allegations that by themselves may be outside the scope of coverage are immaterial, as long as the complaint can be reasonably read to include allegations that are within coverage.
It's similar to a summary judgment standard. We have to review the allegations in the complaint in a light most favorable to the insured.
Correct.
So, counsel, I think we know that part. So can you cut to the chase and get to the employer liability exclusion, please?
I'd be happy to.
I think the allegations here are tricky.
I agree in some senses that they are tricky, but them being tricky isn't enough to deny coverage in light of what I talked about earlier.
Yes, I agree. Yeah. But what's your best argument?
The best argument is that there's no specific allegation that Pedro Domian, the employee, was injured. And in the absence of a specific allegation that he was injured, there can be no injury to his son as a result of such an injury. Didn't the district court,
though, decide or find that the allegations were implying that there was an injury to his reproductive system? Isn't that an injury to the employee?
The district court ruled in my client's favor on the employer liability exclusion. I think, to be sure, there are allegations in the complaint that Pedro Domian was injured. There aren't allegations of such an injury that would bring us within the scope of that exclusion.
Yeah, I think what the district court said was you can read these allegations to allege an injury to the employee's reproductive system and to the mental or emotional injury, but it can also be read to state a claim or allege that there was no injury and that there was injury only to the unborn child.
That's a good point, and I agree with that. Even if the complaint can be read to allege that Pedro Domian was injured, which I dispute, that exclusion only forecloses a defense obligation if the only injuries to Pedro Domian to Nicholas Domian occurred as a result of an injury to Pedro Domian.
Okay, so because we can read the complaint we can reasonably read those allegations to be one or the other, then the employer exclusion is out, and now we look to the pollution.
Exactly.
Except I'm not ready to go to pollution yet.
One or the other or both.
Okay, so could you back up? I think that's right that the complaint, this is the part that's tricky for me. I think you have a much easier row to hoe on pollution exclusion. I'll just put opposing counsel on notice that so we can talk about that when we get there. But before we leave employer liability, please. The reason it's tricky, I think there's an argument you need to respond to, which is, for me at least, that I think the way the briefing went was that your team argued, hey, it could be on this complaint that there's coverage because the complaint doesn't really allege that Pedro was injured. I think that's right. On the other hand, I think it was your client who argued, well, maybe it could be read to mean that the employee, Pedro, carried these substance home. And opposing counsel, of course, argues that's really speculative. The complaint doesn't go there. I think and for me, there's some purchase there in that argument. But I think the thing that I'd like you to grapple with, the complaint does allege that there may have been difficulty or inadequate ventilation, and there may have been trouble with protective equipment. And so, could you elaborate there for me? Because at a minimum, the complaint has to be alleging that that Pedro was a carrier, using that word in the broadest possible sense, right?
Sure.
Transmitter.
Sure.
Somehow.
I mean, I think there's a meaningful distinction between being a carrier and being injured. To analogize for a second.
There is, but we're looking at the four corners of the complaint, and I think the argument that they're making that is I'm wanting you to engage in is, where does the complaint say? I agree, it doesn't say that he was injured, that Pedro was injured. I'm trying to figure where it really says that he was the transmitter.
It doesn't have to,
So you're relying on.
Well, assuming it doesn't have to, can you answer Judge Kristen's question? Because it's the same one I have. I don't find an allegation in the complaint of personal injury to the father. Am I right in thinking about that? And maybe I can imply it as Judge Desai suggested, but I'm asking a very specific question. Is there an allegation in the complaint of personal injury to the father?
Not according to my client. I don't, unless you want to characterize the loss of consortium as a personal injury to the father.
And is there any case law supporting that in order to get around an exclusion, right, that you bake in the non-economic damage on the back end?
Not that I'm aware of.
I've never seen that.
As I stand here today.
I've never seen that. But let's say if the complaint doesn't allege injury to Pedro, and we're relying upon this notion that Judge Hurwitz and I think are both pulling on this thread, that he was at least a transmitter of.
Right.
Where's the complaint say that? Or are you relying on it doesn't have to, it just has to not exclude coverage?
Yes, that's the latter.
It's possible.
I'm relying on the proposition that the complaint leaves open that possibility.
Okay, and so what opposing counsel argues in his briefing, at least, I'm not sure if you drafted the brief, is that that's not fairly in the complaint and that was being, sort of, it's overly speculative. They're reading that in, that it's not really fairly presented. What's your best response to that?
The best response to that is the Security National Insurance versus Sunset Presbyterian and PIH Beaverton versus Red Shield Insurance.
Okay.
Those are two construction cases. They talk about in the additional insured context where an additional insured is entitled to coverage. And they hold that because the complaint didn't foreclose the possibility that with respect to Security National,
I've read those cases.
Okay.
And if that's what you're relying upon, I'm going to let you get to Judge Desai's questions about pollution exclusion, because you've answered my question. Judge Hurwitz, do you have more on this point before we go on to?
No, I'm fine.
Okay. Judge Desai had questions about the pollution exclusion.
I mean, you could just, I was moving to the pollution exclusion because I think under your argument, the employer liability exclusion does not clearly and unambiguously foreclose coverage. So I think, as we suggested at the beginning, you need to sort of tick through all of these exclusions since those are what we're looking at.
Sure. And I'd be happy to answer a specific question. I'd also like to be cognizant of 5 minutes for rebuttal.
Sure. So on this one, can I just tell you, maybe so everybody's on notice, just on my scorecard, I haven't conferred with my colleagues in advance, but it seems to me that I don't have to worry too much about whether this long list of chemicals, that's my word, are pollutants, because I don't see an allegation in this complaint that they migrated or moved anywhere they weren't supposed to be. Rather, it seems to me that the complaint is alleging that he was required to deal with them, interact with those substances in the course of his regular employment.
Right, which means they were exactly where they were supposed to be, which means it doesn't apply to allow Atlantic Specialty to refuse to defend.
So can we just rely on that, or am I missing something? Do I
No.
need to go through the list of substances and figure out what they are?
It's an either or. If they didn't disperse, migrate, all those other words, then it doesn't matter what they are.
Didn't leak, didn't seep,
Sure.
didn't anything.
Can I ask you where the district court got the idea that there was a concession on the issue that these were pollutants?
I don't know. It wasn't an issue that was, briefed in the sense of sections, but it was said at the oral argument that laundry list of substances includes things that are not pollutants. And it was also said that to the extent the court or the insurer isn't sure on that issue, then the tie goes to my client and the insurer had to defend. I'll reserve the rest for rebuttal. Thank you.
May it please the court. Christian Jones for the Appali Atlantic Specialty Insurance Company. This court should affirm the district court's grant of summary judgment in ASIC's favor because the district court properly applied the ASIC policy language to the allegations of the underlying complaint.
Can you start by pointing to where in the underlying complaint there's an allegation that the employee was injured?
There's no claim for a recovery for injury to the employee. I think that we can all agree or assume that that's likely because that remedy would have been pursued through the workers' compensation system. But when the underlying complaint is reasonably read, there's an extensive amount of detail in there talking about how these chemicals to which he was exposed cause reproductive harms to the person who's exposed to them.
I think that what we have here is a gap, and you're asking the gap to be filled in your favor. So we have a complaint that doesn't allege injury to the employee, and then your friend on the other side's arguing that the complaint, at least reasonably read, could assume that these chemicals were carried home on the body, although there's no allegation of that either. There's no clear allegation that there was a transmittal on clothing or on the surface of his skin that he brought home. So we don't have either of these allegations in the complaint. Why don't we read the complaint in a light most favorable to the insured, given that there are no clear allegations of either of these points?
Your Honor, I think that it's because, again, of the extensive discussion in the complaint about how these chemicals work to injure someone and injure their reproductive system and thereby—
Point me to what allegations you're talking about. What specifically?
Paragraphs?
Yeah.
Paragraphs where they— So I agree with Your Honor that they don't specifically allege an injury to Pedro, and that's because Pedro is not seeking to recover in that case.
So if you make that concession, isn't that a threshold issue that we need to be able to say is unequivocal in order to find that the employer liability exclusion unambiguously forecloses coverage here?
don't think so, Your Honor, because again, when the allegations of the complaint are read as a whole and in context and reasonably read, they allege that they injured Pedro, the father, by harming his reproductive system.
There are substances that, for example, pregnant women can ingest that don't harm the pregnant women, but harm their unborn or still developing fetus. Of course, you know that. So why couldn't this be one of those substances? I have no idea what these substances are. But that's what I'm grappling with. You seem to be, your client's position seems to be that there had to have been injury to Pedro. I don't know that.
I think that the impact of the chemicals on Pedro, as alleged in the underlying complaint, would fit within the definition as the term bodily injury is defined in the complaint. I also do think that it's important here to consider the overall context of the two insurers who are fighting over this. Liberty provided employers' liability and workers' comp coverage, risk exposures that arise from the employment relationship, and that's why they defended the insured and provided coverage. And that's why the CGL policy, the commercial general liability policy that was issued by ASIC, has the employer's liability exclusion. That's the way those two policies work together. Even Liberty says, first page of its reply brief, after all, the complaint alleges that the cause of Nicholas Domion's birth defects was Pedro Domion's employment.
Did you make an argument below that the policy that ASIC issued here doesn't apply in any way to defend for these types of claims? Because I haven't. I understand you now saying, look, there may be something about the kind of policy that was issued here that forecloses coverage, but I don't understand that to be the issue that we have before us on appeal.
The argument, if I understand your question correctly, Your Honor, the argument that we were making is that you have two insurers who issued two different kinds of policies. Liberty issued an employer's liability policy. That's the policy under which they provided coverage.
I understand that, but what you're doing is you're zooming back out and saying, hey, this is CGL as opposed to, right? That's zooming back out. And at the top of this argument, I think Judge Desai is getting at, we zoomed in and said there's three, it's not even three, just the policy, there's three exclusions that we should be looking to. So I think Judge Desai is asking, and I'm certainly interested, did you make a broader scoped argument in the district court? Is that more importantly, is that on appeal to us? Or are we looking at those three exclusions?
We're looking at those three exclusions, Your Honor. I mean, I agree that is the analysis, do these three exclusions prohibit.
Then I think I might have been missing your point when you said, hey, my client was the CGL. How does that help us when we're zoomed into these three exclusions?
I think it goes to the purpose and the intent of the employer's liability exclusion. That is,
I'm not sure I understand that argument. So let me just press on it a little. I take it you agree that if the complaint had said father suffered bodily injury because of the facts of this case, and therefore son should recover, the employer's exclusion and the consequence of the son's injuries was because of the father's bodily injury, the employer's exclusion would not apply, correct?
Sorry.
It wouldn't matter that it happened at work because the father might not be able to recover for that bodily injury, but the policy covers the family, and if a member of the family suffers bodily injury as a consequence of the father's bodily injury, the exclusion doesn't apply, correct?
I may not have understood your question correctly.
Well, let me be more clear. It may well be that one of the reasons to stick this exclusion is that there are workers' comp laws. But those laws only prevent the father from recovering for personal injury on the job. This policy does cover injury to a family member that results as a consequence of bodily injury to a father, right?
I would say, actually, Your Honor, this policy provides coverage to the insured Triquint.
That's right. Yeah, that's right.
Rather than to the fact. So claims
coverage the insured for that.
Yes, claims against Triquint alleging bodily injury is what the policy generally covers.
So I'm just not sure why it matters that there are workers' comp laws. The insured says you covered us for this because this complaint alleges liability for bodily injury to a member of the family that was a consequence of bodily injury to the employee. If that's the case, it seems to me the workers' comp laws are irrelevant. We're just looking at this policy, not at a larger scheme. Am I mistaken in that?
No, I think you're correct, Your Honor, and I didn't intend to confuse the issue by bringing up the workers' comp issue. I mean, certainly that explains why Pedro didn't assert claims for injury in the underlying complaint. I think the point that I was trying to make, and maybe not making well, and perhaps shouldn't belabor anymore, is that there is employer's liability coverage that was provided by Liberty, and that is the policy that provided coverage to Triquint for these claims. I'm not suggesting that it is an impossibility that both policies could apply. I'm suggesting that there is.
I'd still like to get back to Judge Desai's question at the beginning, and the complaint doesn't make a specific allegation of bodily injury to the father, but it seems to me, given the detailed allegations of what they're complaining about, why isn't it at least a possible or plausible interpretation of the complaint that chemicals got into his system and therefore affected and then when the child was conceived, affected the health of the child? The second part is clearly alleged. Why isn't the first part at least a reasonable implication?
Why isn't that? Well, I think, Your Honor, because it requires reading things into the complaint that aren't there. And I think an important point is made in the Oregon Supreme Court case Ledford.
We'd have to do that even if we accepted your argument. We'd have to read something into the complaint that isn't there. We'd have to read into the complaint an allegation that Pedro was injured, which is a threshold requirement of this exclusion. Let me ask you a different question. Did you cross-appeal here the district court's decision that the employer liability exclusion was not implicated?
We did not file a cross-appeal. We did note in our brief that when reviewing a grant of summary judgment that the court can affirm or reverse on any ground that's found in the record. So
you made a cross-argument, right?
Yes.
And let me ask you this. I'm going to ask your friend on the other side because, and this is just really a procedural question. If we decide that none of the exclusions unambiguously foreclose coverage, then is there anything to do here other than to direct judgment in favor of Liberty?
Yes, there would be, Your Honor. And even Liberty asked for remand to the district court so that damages can be calculated. They have a claim, saying we spent this much in defense of this case. There's no evidence before the court, on those amounts. Those aren't in the summary judgment record. They also have a claim for interest that they want to establish. So the correct procedure, if the court were inclined to reverse, would be to remand to the district court for further proceedings.
Counsel, I'd like to take one more run at the question that's bothering me. I read the complaint to not allege injury to Pedro. I think that we've all conceded that. And but I also think that it just about has to be read to allege that he was, my word is, the transmitter of whatever harmful substance. And I think there are substances, we all know this, that can harm an unborn fetus that wouldn't necessarily harm either parent. So what I'm trying to figure out is how you can prevail on this list of chemicals, because I don't know what they are. I think you'd have to show me that there's no possibility that he transmitted, that's my verb, and I think that the closest I come to seeing this anchored in the complaint as opposed to just reading something in, to use your word, is that it alleges that there was inadequate, personal protective equipment. So how is it that I know that there's no possibility for coverage here?
There's no possibility because the mechanism of injury is that the chemicals harmed Pedro in some way. And
why does it have to be that they harm Pedro? That's the nub of it. Why does it have to be that they harm, as opposed to him being this sort of transmitter of something that would harm his unborn child?
So say, to take the example I think the district court used, that he could have had them on his clothes and brought them home. Well, that's not specifically alleged in the
But what is alleged, and we can't just sort of make things up. I'm with you on that part, which is why I was giving your friend on the other side, kind of hard time and pushing back on this one. But I don't think it entirely is just made up or read in. The complaint alleges there was inadequate protective gear. So that leaves the possibility that maybe it's inadequate gloves and he brought it home on his hands. Maybe it's inadequate something else, coveralls, and he brought it home on his clothing. But that seems to allow for a theory there that he could have transmitted a harmful substance home.
Well, that same allegation, I think, supports the overall theory articulated in the complaint that they harmed his reproductive system. If he had had adequate protective equipment, they might not have harmed his reproductive
Counsel,
system.
Paragraph do you want us to look at? I'm sorry, Judge, again, you keep saying that. What paragraph is it you want us to look at for the allegation that Pedro's reproductive system was harmed, that Pedro was harmed?
I can't point to a specific paragraph as I sit here.
Can you point to anything in the complaint? Because I have the same question Judge Kristen does, and you used an interesting phrase, and one that sort of I use when thinking about this case too, which is what is the mechanism of injury here? And I scoured the complaint to find an allegation that talked about the precise mechanism of injury, either to Pedro or to the child, and I can't find it, and you use that word, so it makes me think that you're thinking about something in the complaint that talks about the mechanism of injury. Where is that? Can you point to any allegation in the complaint that talks about that?
As I stand here, Your Honor, and I'd be happy to submit any supplemental briefing or letters to pinpoint those.
This is the entire case. It seems to me that if I've looked at it and you're preparing for argument, which I'm sure you did, that you would be able to point us to something in the complaint that talks about the mechanism of injury.
And our argument has been that it's the overall discussion, the complaint over and over and over again, and we've cited to numerous instances in our brief where it does this, talks about reproductive harms. It's said over and over again, and as the Ledford Court noted, to adopt the District Court or Liberty's reasoning here puts the insurer in the position of getting in a complaint, and the insurer has to try to make a decision about whether they have an obligation to defend it. And
but that happens all the time. I mean, the duty
Sure.
to defend is that the sort of principle behind the duty to defend is that you go in and you defend, and then you can seek subrogation if your defense was
I would say what Liberty's position does, Your Honor, is puts the insurer in the position of having to imagine other potential theories of liability that could be covered even if the face of the complaint doesn't allege it. And Ledford says that that's not a reasonable way to read the complaint.
I think that's your strongest argument. And I'm going to ask you to pivot because you're out of time. And I just would like to get, if I could, I want to give Judge Hurwitz a chance in case he's got another question. And I'd like you to answer the question I put to opposing counsel, which is on the pollution exclusion. Do we need to get to whether these are pollutants or not? Why can't we just rely on the allegations that I think fairly read? The complaint says that Pedro's job required that he regularly come into contact with these substances.
I don't think that the court needs to address the issue of whether these substances were pollutants. Liberty raised no argument that they were not pollutants below. At the most they can point to is one sentence in oral argument, and then one
So
sentence.
let's say they're all really toxic, counsel. My question is, I don't think they leak. There's allegations about them leaking or seeking or an accident. That's not what we would typically see in this kind of a case. And I think that for me, the pivot point is that his allegation is, I had to work with this stuff all the time. It wasn't a leak or a spill.
I think there I would point to the district court's reading that, where the district court found that the only way to reasonably read the complaint is that the chemical products somehow discharged, dispersed, or released in order to cause the harm that's alleged in the complaint. And I would say also that reasoning in the district court's opinion supports finding that the employer's liability exclusion applies, because it's this is the only way to read these allegations when taken as a whole.
Okay.
But aren't you now reading, I'm sorry.
No, I was just going to turn to you, Judge Hurwitz. Do you have follow-up?
Yeah, aren't you now reading the pollution exclusion language which says discharge, seepage, migration, release, or escape to also include the word exposure, which is not in there? In other words, I can read the complaint as saying I was required to work with chemicals on this job and was exposed to them. They weren't discharged, seep, migrate, released, or escaped. I actually had to touch them in order to do my job. And that doesn't seem to be covered by the exclusion. Well, can you respond to that?
I think, Your Honor, again, as the district court found, that
Well, I know what the district court found, but it was just reading the complaint. So let's assume that the district court never made a ruling on this. What's your best argument about why mere exposure, as opposed to intentional exposure, perhaps? I'm giving you this pollutant to work with on the job, and we didn't provide sufficient safety measures, et cetera. But isn't that just exposure rather than one of the excluded events?
Your Honor, no, I would say that based on the allegations of the complaint, there would have had to have been some movement of those chemicals to places where they weren't supposed to be in order for the injuries alleged to have occurred.
Anything further, Judge Hurwitz?
Thank you.
Judge Desai? I want to thank you for your patience with our questions. We've taken you well over time, so I'll leave it at that.
Thank you. Just a few quick notes. This complaint is...
Can you answer a question I asked your friend on the other side, which is what procedurally is the appropriate next steps if we were to agree with your argument and find that the policy exclusions don't apply here?
It's a remand. These were motions for partial summary judgments only on the issue of the duty to defend, and there are further things to determine once that threshold question is answered.
Like what?
What the split is, what the spend was, and
so it's damages. It's a damages calculation,
sure,
as your opposing
big cloud
counsel
of
said.
damages. Okay. Yes, yeah. This is, as I said, this is a really long complaint, and there's extensive and repetitive language about risk of harm and exposure. It doesn't matter how many times they say the phrase risk of harm or how many times they say the word exposure. They're just saying it again. What they would need to clearly and unambiguously allege is a bodily injury to Pedro Domian, and they don't do that despite the length of the complaint.
Opposing counsel argues that it has to be fairly read to include reproductive injury. What's your response to that?
It doesn't, because the transmittal carry on the clothes theory is a viable theory.
And where is it grounded in the complaint?
It's implied, and it's not foreclosed. I'll grant that there's no paragraph that says Pedro Domian carried one or more of these substances home on his
What's
clothes.
the closest it comes? Where's the best anchor you've got? You have to have an anchor.
Counsel, doesn't the complaint talk about exposure? And as Judge Hurwitz pointed out, there is really no. I think of the words under the pollution exclusion to be environmental terms of art that talk about sort of pollutants in the sense that they are released into the public. What doesn't the term exposure perhaps imply that there was something carried but without causing harm? It's mere exposure to him. He has it on his body, his clothing, and then it causes the injury to the child without it causing injury to him?
I agree with that.
But I'd like you to hear an answer to my question, if I
Can
can.
you repeat your question?
Bet. What's the best you've come? You've got to have an anchor in the complaint. What's the best you've got to read this in?
To read in that Pedro Domian carried the...
Yep, or was transmitter. What's the best you've got?
I'm not prepared to point to a specific section of the complaint.
I wasn't trying to put you on the spot. Well, maybe I was. But anyway, not to worry. We'll take your argument as a whole.
Sure.
Go right ahead.
The idea that some of these substances are not pollutants, it was preserved. All you have to do is make an argument at oral argument, and I did so. And to reiterate, even if it wasn't preserved, the dispersal type thread of that exclusion is still a viable theory. And finally, I think the idea of protective equipment actually helps Liberty here, because there's an idea of whose protective equipment were we using and what was the intent and what was the knowledge. In light of how general all these allegations are, you would have to go substance by substance on this protective equipment protects against maybe the first 5 substances in this list.
Isn't that the anchor that I was just asking about? Isn't that the closest you come to saying that we're not just reading it in, there's an allegation that the protective gear was inadequate?
Sure, I agree, yeah.
It wasn't a trick question. I just think that that's the closest I come, and I've asked both of you. That's the closest I think the complaint comes, and I've tried to be really upfront about the fact I think opposing counsel's right. We can't just read something in whole cloth, but I don't think that that's what we've got here. I think there's at least that.
Yeah, I agree.
Let me just ask and make sure before you leave the podium. Judge Hurwitz, do you have something else?
I do not.
Judge Desai?
No.
Okay, I think we're done.
Thanks very much.
Thank you both for your patience.
Judge
with us.
Kristen, can we take a very brief break? I should be back in 60 seconds.
Okay, well, we're going to take 5 minutes. So
Okay.
we'll be off record for 5 minutes. Thank you.
Court, all rise. The court stands in recess